Hi, everybody. Good to see you all.
Good to see you too, Jen.
Yeah, thanks for joining us. You're outside of your normal business day.
Oh, it's okay. Yeah.
I'm recording it too, though, if you need to go to bed. These are
Okay.
long days for those of us working in this field.
It's okay.
Okay, we'll go ahead and get started. Folks are still joining us. Hi, everybody. It's nice to see repeat attenders. Thank you for coming out. So this is the last, what's supposed to be part four in a four-part series designed to get us ready to do affirmative asylum cases. So tonight's topic is brief writing, specifically for affirmative asylum. Very interesting topic. I've actually never
Oh,
been to a
yeah.
training on this topic before, so hopefully we'll be able to cover quite a bit of ground quickly. So I kind of organize this into two parts because we come to this work with different backgrounds. So there are some lawyers here. There are folks who have limited legal experience. There are folks who've been through certificate programs, folks who have a lot of experience in the field. So that just makes us all start at different points. So we are first going to cover like background, like legal authority, jurisdiction, that kind of stuff. And then we're going to look at two examples from real cases because I think the best way to learn always in the advocacy
But
world
I am
is
working.
through actual cases, like actual casework. So I will try to go a little bit faster at the beginning through the background stuff, and I'll pause for questions, of course, and then we'll slow down to go through the examples because that's really where the learning happens. Okay, so I'm just going to share my screen and I'll show you the PowerPoint. Okay. Okay. So the brief or the legal argument. So, as with everything in immigration, there's a lot of synonyms. Like some people refer to the brief as the memo or the memorandum or the cover letter or the case assessment. It's all the same thing. My understanding is that asylum officers call it the case assessment, just for what that's worth. So I think, as we start thinking about this, it's really important to know your audience, always as an advocate. That's really a starting point. Think about your audience. So I hope you come back to this visual for the entire duration of your legal advocacy career, like this idea of spoon feeding. I am convinced that in today's world, people have very limited attention spans. Everyone, for the most part. There's, of course, exceptions, but I think it's normal. So if you have that in mind as you're writing an argument or as you're trying to convince someone, I think it really helps. It's effective to think about how we want to make it as easy as possible, in this case for the asylum officer, to understand your case and to just approve it. So I know we've talked about asylum officers in this training before, and I mean no disrespect to asylum officers because I've actually had very positive experiences with them, but their system is just really flawed, especially now. So they're making a lot of mistakes. So again, yet another reason, like spoon feed wherever you can. So I hope you will remember this adorable little chubby cheek kid as you're writing your briefs and assembling your cases because that's the idea, spoon feed wherever you can. So with that in mind, um, let's talk about, folks who will be adjudicating these cases. Asylum officers are super busy. Like what I've heard about their caseloads, it's alarming. It's horrible. Their quotas, like the cases that they have to adjudicate every week, I don't know what it is now. They don't talk to us, they don't disclose that, but it's very stressful and they're very rushed. A lot of times they have limited training in the law. Some are lawyers, some are not. But regardless, quite a few of them start out with only 6 weeks of training in asylum law, which is, pretty limited considering how complex this practice area is. So, that's a little bit about your audience. But thinking longer term, if this case, your affirmative asylum case, is referred to court, then it's an entirely different audience, right? Approval rates right now in courts tend to be lower. Generally speaking, your audience is going to be more sophisticated. Um, There's obvious exceptions to that now, but that's been the history that an immigration judge would be more sophisticated than an asylum officer. So you always want to think long term. If your client is referred to court, you want to lay a good foundation with your brief so that it can just be supplemented if and when it's referred to court. Okay, so let's think about sources of the law. So the rules that you're arguing. Um, so I think under an administration like this, it's especially important to be savvy. There's a lot of reasons for that, but one big one is that we're seeing a lot of success among federal litigators. So, like our cases, when they're decided in the executive branch, they're just harder to win because this executive branch is hostile, right? We all know that. But if cases make it into the federal court landscape, we're seeing a lot of success. And in order to do that, you have to have sophisticated arguments. So I think that's just helpful to keep in mind. But let's talk about like what are the actual rules that you're arguing apply to your client and that your client satisfies. So here are the big ones. The statutes. So immigration law is federal. They're always federal statutes that we're arguing, with a couple minor exceptions like special immigrant juvenile status. Those cases involve state law, but generally you're arguing federal statutes. And then regulations are issued by agencies like within the executive branch, and they're supposed to provide clarity and implement the law. But I'd say over the course of the last decade, they've generally just made immigration relief more restrictive, like harder to obtain. And then you have case law. So case law it's basically like a judge or an adjudicator applying the law to a set of facts, saying like, okay, this is how this person in this scenario does or does not satisfy the law, and here's why. So case law provides guidance to future scenarios. And this is where, like, if you don't have a background in law school, it's probably a little bit harder, but that's okay. Um, you can still do all of this work without going to law school. It's just a little bit easier if you took the 3 years to dig into case law and understand legal analysis. I think one thing that's helpful to know about immigration judges is that they're not independent. So they are appointed by executive branch leaders. So the Department of Justice, which is the umbrella organization that they all work for, has a lot of control over how they decide cases. And that's in contrast to what we call Article 3 judges, meaning like Article 3 of the Constitution creates an independent judiciary so that judges have a lot more leeway to decide based on their own like interpretation, their own judicial philosophies, that kind of thing. So it creates some trouble for us, of course, which is why I mentioned what I did earlier about having success in the federal litigation landscape because those judges are more independent, generally speaking. Okay, so I would say these are the three big ones, the three big sources of authority that you're arguing. But because immigration law is constantly, there's other things that you could argue to support your client's case. So there's all kinds of policies. So I think the easiest way to explain this is that the executive branch has a lot of authority over immigration and what happens and what the regulations are, all of that. And they create policies for how they want to prioritize and handle cases, handle like different groups of people. And so those policies become controlling. As we've seen under this administration, sometimes those policies are enjoined, meaning like a court, an Article 3 court, blocks the policy from going into effect or blocks part of the policy. So this concept is pretty broad, but it's helpful to know about. So like tonight, I shot out an email to the Philadelphia AILA listserv. That's the American Immigration Lawyers Association, because I was asking about a specific issue involving UACs, unaccompanied alien children. And I just learned about a new policy that was enjoined involving those kids that I didn't know about. So this is so vast that we pretty much have to rely on each other to keep informed about policies, and especially rely on the experts who keep up to date on all of these changes. And then there's also procedural rules. So I think the best source for us when we're working on affirmative asylum cases is found in this link. So this is a hyperlink, the Affirmative Asylum Procedures Manual. It's really helpful. It gives a lot of instruction about how you file things, what the expectations are from the asylum office. And those are, again, like rules that we're arguing our client is following and entitles them to relief. Okay, so I'll pause there. Those are the big sources of authority. Any comments, questions? Okay. Okay, so just thinking again, like bigger picture, you might remember this slide if you attended the last presentation. These are the big elements that you're arguing your client satisfies, and therefore they qualify for asylum protection. So this is kind of what you're always on the lookout for as you're assembling your case, because you're going to want to have something to rely on when you're making an argument on one of these elements, rather than just something vague or speculative. So I'm just highlighting this slide because I think it's probably the most important slide in all of these presentations for you to screenshot or remember to pull up when you're working on a case. Okay, so jurisdiction. Jurisdiction means who decides the case. Or in other words, like where is it decided? Because those are pretty interrelated questions. So jurisdiction is interesting in immigration. So if the asylum seeker is not in removal proceedings, you almost always file with the asylum office. And you can find out which asylum office has jurisdiction over your client by clicking on this asylum office locator and putting the client's zip code in that locator where they actually reside, and it'll tell you where they have to go, what to send their application to, and also where they'll have to go to interview. And then if the asylum office does not approve the case, if the person is in lawful immigration status, basically nothing happens. It's like a denial, but they're not put into removal proceedings. But if the person is not in lawful status, then they're placed in removal proceedings before an immigration judge. And most folks would fall into the second category because the backlogs are so long that most people, they lose their underlying status because it expired by the time their case is actually adjudicated. So interesting like hiccup with this jurisdiction issue. A lot of folks, since I've been doing this for 10 years, have crossed the southern border and have been handed a notice to appear. That's the charging document for a civil immigration violation. But that NTA, the notice to appear, is never actually filed with the immigration court. It's just handed to the client, right? And then they come on in and they want to apply for asylum. Well, that's not enough to give the immigration court jurisdiction over the case. The NTA actually has to be filed with the immigration court to vest jurisdiction with the DOJ, EOIR Immigration Court, over your client. So if that didn't happen, then your client should file with the asylum office. So there's a lot I could say about that, but I'm trying to keep this on the briefer side because that's super common. And clients get confused when they have a charging document, but they don't have a court date. Okay, comments, questions?
Just
Go ahead.
what happened when it was submitted to UC's the asylum, and then now they have a court date. They do have they do have an appointment for the interview, but also they assign a court date.
Yeah, so that's really complicated. It really depends on the factual scenario. Because there are carve-outs. Like for UACs, I have a client in that situation right now. The asylum office has jurisdiction over his case because he's a UAC, even though he's detained in removal proceedings. But for a lot of folks, um, the asylum office is going to lose jurisdiction. And when the NTA is filed, jurisdiction is just going to vest with the court. But there's just so many complications in this area of law, it's hard to give generalizations because there's exceptions for everything.
Okay, thank you. It's like sometimes I say like it's a mess.
It is, absolutely.
It's it's here and there. Like a mom comes with 2 years old and the kid has a court date, but the mom doesn't have a court date, and the mom goes asylum goes to UCIS, and the daughter needs to show up to court. It's
Yeah, it's really
confusing.
complicated. And then sometimes you want to consolidate cases because you want someone to be a derivative on a stronger principal application. Yeah, so it gets complicated very fast.
But and then the judge said that they won't be able to consolidate the case because in this case the mom doesn't have a court date.
So they don't have jurisdiction over her, probably.
Yeah.
Yeah. Yeah, common problem. Okay, so case law, thinking of the hierarchy. So the legal field in general is pretty hierarchical, which makes sense. Like you have levels of authority, right? Like lower level judges are bound by appellate level judges and their decisions that are binding on a lower level judge. So in immigration, because it's administrative law, administrative meaning that it's under the executive branch, so not that Article 3 uh, court that I mentioned, it gets weird. So I'm going to just go through this quickly. So if you're interested in it, you can read about this topic on your own, but I'll give you a high level view so you at least understand kind of the controlling case law situation we're in right now. So um, asylum office decisions, they're not like published or available, so we have no way of relying on them as like persuasive authority, right, to give another asylum officer. So we start with the immigration judge. That's really where the case law starts for us. Um, and so if you have an immigration judge, you might want to file on that judge a previously issued decision to remind him or her, hey, this is how you ruled in the past and it was in a client's favor. You should rule the same way in my favor, my client's case this time. So there are scenarios like that where you might want to file an opinion issued by an immigration judge, but it's not controlling. So that's kind of the lowest level, right? Above that, so say your immigration judge denies your asylum case, you could appeal to the Board of Immigration Appeals. So that's an appellate board that issues decisions that are binding on the immigration judges. So right now, the BIA for short, it's horrible. They're incredibly biased. They're issuing just by and large very negative decisions for all cases. And on that same kind of tier with the BIA is the Attorney General. So you might be familiar with the Attorney Generals under the Attorneys General under Trump administrations like to refer cases to themselves and then overturn case law they don't like. So we saw that a lot with Jeff Sessions. It's happened with Attorney General Bondi. And so again, it's kind of the same idea, right? You have the immigration judge, then you have the BIA and the Attorney General overturning a lot of favorable cases for immigrants. That's the second level. The level beyond that is the circuit. So this is a federal appellate court. So say that asylum case I mentioned, you appealed it to the BIA, you still don't like that decision, then you would appeal it to your circuit. Well, the circuit that applies to your client. So it's a little funky, right? Because like you're going to a federal appellate court rather than like a federal trial court, right? Which is where you generally start out in the federal system. No, this is different. You go to a circuit court. So to make matters like a little more confusing, for many years there was something in place called Chevron deference. So I put links in here. If you're interested in this, you can read about it. But I'll just give you like a brief synopsis. I'm going to go back to the prior screen. So for many years, these circuit courts were limited in terms of their ability to rule on issues because this idea, Chevron deference, created by the Supreme Court, limited them. So if a statute is ambiguous, Chevron deference required them to defer to the BIA's interpretation of the law. So it kind of inverted this last arrow to create situations where circuits were really limited in terms of what they could review. So the BIA had a ton of power over immigration law, in other words. Well, this Supreme Court in 2024 overruled Chevron deference. That's this case, Loper Bright Enterprises, saying, no, we're going to restore power back to the courts so they can function as Article 3 courts, right, with their independent judgment. And so now the hierarchy that we see is, well, sorry, is more consistent with these arrows, right? Because the BIA and the Attorney General level, they're kind of in their place now. The circuits have a lot more say over ambiguous statutory language because the Supreme Court said, no, courts have power to review ambiguous language. We need to restore that, keep the courts independent. So hopefully that makes sense. This is very confusing stuff, but it's good news for us, which is why I wanted to explain it. And I'll get into an example of that in a minute. Okay, so circuits. They are regional. These are all the circuits that exist in the United States. So I know a lot of us are in Pennsylvania. You can see that's the Third Circuit, because the Third Circuit encompasses Delaware, New Jersey, and Pennsylvania. But jurisdiction gets a little bit weird because jurisdiction generally applies like where the adjudicator is. So here in Western Pennsylvania, if you use that asylum office locator that I mentioned, if you put in zip codes for Western Pennsylvania, you'll see that our clients interview down in Arlington, Virginia. And you can see Virginia is part of the Fourth Circuit. So Fourth Circuit case law is controlling, which is awesome because Fourth Circuit case law is actually very good for immigration law in general. I think it's comparable to Ninth Circuit case law in a lot of respects, which is great. So that's why I mentioned earlier this overruling of Chevron deference by the Supreme Court was very good because we now have access to precedent that is controlling that helps our clients. Okay, so thinking about, I mentioned we kind of need to be savvy in this environment. We want to put forth strong arguments that can withstand scrutiny and maybe make it to the federal system. I can tell you for us in Western Pennsylvania, we want to rely on Fourth Circuit precedent as often as we can because the BIA and AG precedent is so bad right now and it's just going to get worse for the next 3 years. So we do a lot of research on the federal case law and try to rely on that rather than distinguishing our cases from bad precedent from the BIA and AG. So I can give you an example. I know I've talked about this a lot. Family-based particular social groups are very strong in the Fourth Circuit. The Fourth Circuit has said repeatedly families can comprise particular social groups. Now, remember thinking back to like Chevron deference, particular social groups are ambiguous. Like the statute doesn't define what that means. So this is a perfect example of why the court overruling Chevron is very good. We want to rely exclusively on Fourth Circuit interpretation here, which is good because sadly around the world, a lot of persecutors do target families because it's a really effective way to force people to do what you want them to do as a persecutor by targeting their loved ones, right? So there are some good things happening now, regardless of what the AG and the BIA want to do to destroy and limit asylum protections. Okay, so hopefully that gives you a little bit of a foundation of like what you're arguing, what you need to research before you type up your memo or your brief. But these are some counterintuitive points that I've discovered as I've done this work. So it can actually be hard to find case law to support your case if it's strong. And the reason for that is that case law is developed through appeals. So like say, I think some of the easiest asylum cases to argue are religious persecution cases, just because it fits so squarely within the statute. So say, you know, So I'll give you the reason why asylum law was developed. It was developed in the aftermath of World War II, right? Say that I am Jewish in Germany, right? And it's 1946. Obvious religious persecution claim, right? That is the kind of case where it's going to be really hard for you to find case law supporting your argument because it's so strong that it's likely to just win at the first round, like at the asylum office or the immigration judge level. So you shouldn't get nervous if you have that predicament where you don't have much to kind of hang your hat on. It's because your case fits squarely within the protected ground in the statute. And that itself is a good, powerful argument to make. Um, Sort of related to that, the case law generally doesn't elaborate on obvious points, kind of for the reasons I just mentioned. There's exceptions. Sometimes a court, or like at the BIA or the AG or a circuit court, will elaborate and say something that is obvious just to create clarity, like, no, this isn't more complicated than it sounds, like we're making it simple here for you. Here's an opinion explaining that, yes, like religion in the statute means religion. Sometimes you see case law like that, but generally you don't, which again is why, like, if you have a strong case, you might not have case law to rely on. This is kind of a sad point. If you read a lot of case law interpreting asylum law, it's generally bad. It generally denies the client relief. But that's okay because we are arguing the legal analysis. Sometimes we're distinguishing our client's case. Like the facts that we're arguing are different than that client's facts. And it's been that way ever since I've been doing this work. So even if you get a case where the client was denied, there could be some really useful language in there for you that you do want to rely is applicable to your client or that your client satisfies. So you're not necessarily looking at the outcome. You're more so looking at the rules and the analysis. And so a couple minor points for lawyers, if there's any lawyers in the room. So in law school, you're generally taught a very formulaic approach to legal writing so that you leave your reader with a super clear understanding of what your argument is. So it's repetitive, it takes a while to get used to. That is something you do not want to use in this context. One, because asylum officers tend to be less sophisticated and that will be lost on them. And two, if you're in an immigration court context where you might have a very sophisticated immigration judge, there's just not enough time to cover all the material you need to cover in the limit that you have, which is 25 pages. So all this is to say, like, regardless of whether you went to law school, what your background is, this is kind of just a different way to write than you would in other situations as an advocate. Okay, so we'll get into our two case examples in a second, but we developed our headings, like our outline that we use for our briefs from Vicina. So they sent out a template, I think like 2.5 years ago, which is based on the asylum officer's case assessment that they have to write up for every case. And this case assessment is what they send to their supervisor with their decision, like justifying whether they approved the case or denied the case. So that's why we use it. Like we of course just want to give spoon feed, right? Spoon feed the officer so they can just copy and paste what we wrote, approving the case. So I've tried to get clarity recently on whether the asylum offices still use this template that you'll see me pull up in a minute. And we just don't know. This administration lacks transparency, to put it nicely. So we don't know. But we do know that in the past they used this case assessment kind of formatting. So that's why we keep using it. And it covers those main elements that I pulled up on my favorite slide. It covers all of those so that our bases are covered legally. Okay. And then, so last thing before we get into the examples, these are a couple resources for you if you really want to do a deep dive on this topic. And they're all hyperlinks, so you should be able to access these from home. So this last link here, the Fourth Circuit cases, this is a compilation of Fourth Circuit cases based on the holding. So a holding is basically the rule developed in an opinion. So in the case law, it's like the main point that the court is deciding. And so there's different synonyms for that, but the holding means like what is controlling here forward and what will apply to other people who will have their cases decided. So the Fourth Circuit cases in this website are divided up into those holdings, like topics. So you can go to this website and just do a control find based on what your protected ground is or the issues you're dealing with. And it's awesome resource. Usually whenever I get a case, I do that. That's one of the first things I do to see what kind of legal arguments I have at my disposal from the Fourth Circuit. But even if you're in different circuits, the immigration field is really impressive, like the nonprofit sector in compiling these kind of resources because none of us have the time to really do that on our own. So we rely heavily on folks who do policy work and like this high-level legal work to do that grunt work for us. So even if you're not in this circuit, you can probably find something comparable and it's very, very helpful and saves you a lot of time. Okay, I'll pause before we get into the two examples. I see something in the chat. Oh, no, okay. Any questions?
When the BIA deny a case and you want to go up to the circus, but they denied the case because it was 2 days um late. It looks like they didn't even care about reading the reason why. Do you think it's worth it to just escalate to the circus?
Honestly, I have no idea. It's very hard to give like generalized advice. But there are other considerations too. I will say, even if you have like a low chance of success on an appeal, sometimes your client might want to take the risk because an appeal can be a stay of removal, right? Preventing the government from immediately removing the client. So I will say there's other considerations. You never want to file anything that's frivolous, right? Not rooted in law or fact, something that's like clearly going to be denied. But there's all these other kind of competing considerations. But yeah, it just depends on the situation in that case.
The 290B needs to be sent with?
So it really depends. Like that's with USCIS. I'm not sure if this is, if it's, yeah, it depends on the procedural posture of the case. Immigration law is so complicated. I wish I could give clear answers, but it's very hard to give generic feedback.
Okay, thank you.
Sure. Anything else before we get into the examples? Okay. So two examples. The first one is a straightforward strong case. So this is the kind of case I mentioned, like there wasn't a lot of case law for us to hang our hat on and say, like, this applies, this is why you should grant this case, because it's just like this other Fourth Circuit case. Not the situation here, but that's okay. It's very strong. So I think the easiest way to wrap your head around this and understand legal analysis is to really take your time. Like, if I were you, I would read both of these and take your time and read the comments and think about it. Think about if you could have made the argument stronger. Think about any weaknesses. That's really how you sort of develop those muscles to make arguments. Okay, so I made a couple of notes because some of this is self-explanatory and then some I think is worth highlighting. So I'm going to pull up the comments here. Okay. So you can see the headings that I mentioned. This all comes from Vicina. Vicina is awesome. I'd highly recommend their training materials. So some of this is what you would expect. Here under the basis of the claim, you need to really spell out your protected grounds, even if they're different for the past and for the future. So I think one of the things that is easy to do in asylum law is to kind of smush the elements together. Because like nexus and protected ground, it's kind of easy to put them together and argue them as if they're intertwined. And they are related, but you need to separate them out, right? So like going off of the religious example I mentioned, I'm a Jew in Germany in I think I mentioned the wrong year, 1944, whatever, whenever World War II is going on. So me going to a religious service celebrating Hanukkah, right? That's the protected ground. I am Jewish, okay? But a Nazi coming up to me and asking about my religion and then detaining me for it, that's the nexus. So I'm mentioning this because when you're new to this practice area, it's really easy to just smush them together, and that's not what you want to do. You want to separate them out. And you really want to start that from the beginning under the basis of the claim. Make sure that you are clearly articulating what those protected grounds are, and then you'll get to nexus later on in the memo. Okay, so you always want to address the 1-year filing deadline, even if your client, it's not an issue for your client, they filed within 1 year of entry. One of the reasons for that is that asylum offices like to boot cases to immigration court by claiming that the 1 year bar is not satisfied. So you just want to get that out there, address it head on. There's quite a few exceptions to the 1 year filing deadline. This gentleman qualifies for 2 exceptions. I won't get into that, but you can read it and I think it'll be pretty clear to you. And then summary of testimony and credibility. This is where you're distilling down the client's affidavit into the legally relevant facts. So you want this to be really short and very sweet, like very relevant. Again, I think another mistake in humanitarian work in general is overemphasizing the compelling facts, like the sad facts, right? And then not getting into the legally relevant facts. Because I think there's just so much like desensitization that happens. A lot of adjudicators really don't care about the severity of harm. They care about whether you satisfy the elements or not. So think back to that slide that I had, the favorite slide with all the elements, like making sure those are covered to the extent possible in the summary of testimony and credibility. And so here it's a little tricky because these are real cases, so I had to redact. But basically, I can give you just a quick summary. So this gentleman, he's from Indonesia. He's a Christian. He was serving in his government. And one night, gentlemen were masked and they came into his room when he was in like this training camp and said, "Hey, are you a Christian?" He said, "Yes." They took him off and they tortured him. It was really bad. He lost consciousness. They dumped him back in his room. He sought out help, like reported it. No one cared. No one investigated. He went to the hospital. People really minimized the harm, like the doctors and everyone providing him care acted like nothing bad had happened. And then I won't go into too much detail here just for respect for the client, but there was another incident where this client sought out medical care from a hospital in Indonesia for a family member. And this family member was basically neglected and died. And so he contrasted the care that that family member had from the hospital that they received to the care that other non-Christian patients at the same hospital received, which was much higher quality. And during that hospital stay, he was repeatedly asked, "Are you a Christian? Are you a Christian?" So like very out of, like, why would you ask that question, right? In a high stakes situation where there's risk to a patient. It's just irrelevant. So it was pretty much insinuating that there was religiously motivated medical neglect. So that's a summary of what we outline here in the summary of testimony and credibility. And if you notice, like the way I just explained it, I'm talking about protected ground and nexus, right? Those are all the facts that I just gave. So that's what you want to focus on there. Okay. Past persecution. So remember, this is a threshold question. Does the harm rise to the level of persecution? Because nexus is so important, I think it's the most important element in your case. You can repeat it throughout your affidavit. So like I talk about how the harm rises to the level of persecution, right? In the top couple of sentences here. And then I say separately, we know that nexus is satisfied, right? On account of, because they asked him if he was a Christian before they captured him and attacked him. And one fact I failed to mention was that during the torture, he cried out to Jesus, something like, Jesus, help me. And the attacks escalated. So that's really powerful nexus facts, right? So I put it in here, nexus, you can see that. And then I repeat it throughout the brief. You'll see I highlight where I talk about nexus. And that's for a reason. Like, I don't want these officers to mistake the harm that he suffered for something, anything other than religiously motivated, because that's how you win your case. Okay, so well-founded fear. Forward-looking, how do you argue something that hasn't happened yet? It's a little weird, right? Well, there's a four-pronged test in matter of Magherabi. I'll let you read this portion of the brief on your own, but this is pretty characteristic of what you're going to see in terms of like 3 or 4 pronged tests interpreting statutory language. It's sort of weird. Like, where do they come up with these things? But they do, and then you just argue that you satisfy all the prongs. So I think that's pretty straightforward. So you're going to argue this test really in any case where there's a well-founded fear of future persecution, which you're always arguing. Like, there's not going to be an asylum case where you're not arguing that. Okay, so well-founded fear, future looking. You can argue the case law. I just mentioned the Magherabi case, but there's also regulations that give guidance on that. So that's what I mentioned here, that this gentleman has a well-founded fear claim based on the case law and also under the regulations. You can see, excuse me, right here. If there's a pattern and practice of persecution of similarly situated people in the country of origin, you argue that there's a well-founded fear based on that. So other people with the same characteristics suffering harm, suffering persecution. So in this particular case, we had a fantastic expert witness who explained the situation in Indonesia for religious minorities like Christians. One of the reasons why his report was so helpful is that there are a lot of Christians in Indonesia, and sometimes that kind of hurts your case. Like, if your group that you're arguing is persecuted is very numerous, that can hurt your case because our government's going to say, well, there's tons of people like that there. They're fine, right? Well, no, they're not fine. So you can see this is a really powerful quote. He explains, I'll read it here. The Indonesian government's aim appears not to be to create an atmosphere of religious freedom, but to insist on a deference to the Muslim majority in the name of harmony, even going so far as to arrest victims of threats and physical violence whose religious consciences cannot acquiesce to religion they do not confess. So basically, in his report, he explains that the country of Indonesia says that it's a place where religious freedom is valued. The government enforces this idea and wants people to follow their conscience and live free, practicing their religions. This gentleman, this expert explained, no, like they have this concept of harmony where they want to like butt out of religious disputes. And the only way they do that is by favoring the majority. So they will say, like, look, to keep the peace, to keep the harmony, it's Muslim majority. Like, we're just going to let whatever, like, the Muslim determination is, let that stand. And other people have to acquiesce to that. So it's a very helpful explanation that he gave us. And so I'm highlighting this here because we couldn't find that kind of information through our own country conditions research. It wasn't that articulate. It didn't spell it out like that for us. So finding good experts is really helpful and really increases your chance of success. Okay, I think that pretty much gives you the high points in that case. Comments, questions? Okay, we'll go to the second case, which is quite a bit more complicated, but I think very relevant because the fact pattern in this case is very common for Northern Triangle cases, so cases from El Salvador, Honduras, and Guatemala. So I'll give you just a little background. This kid, he's 18. When he was about 3, his parents were murdered. He lived on the street in various abusive homes. And El Barrio 18 murdered his parents and then came after his family unit also. So they killed two of his brothers. They came after him, forced him to pay extortion money or la renta. They ran him over with a car. They did all kinds of horrific things to him. They abducted him. Um, and when he was abducted, his adoptive family reported the abduction to the police in Guatemala. And then the police informed El Barrio 18 that a report had been made because there was corruption and the gang members paid off the police so they could have like this intel when a police report was made against them. So those are kind of like the high points for this case. So you can see like the way I wrote this was a little bit different. So I led with a procedural issue. You can see here, I'm arguing that he's an unaccompanied alien child. So there are a lot of protections for immigrant kids embedded in the INA, the Immigration and Nationality Act. But our government just does not want to abide by these protections. Honestly, it's despicable. So that's why I lead with these issues, so they cannot just bump this case to court because the Asylum Office has exclusive jurisdiction over UAC cases. It's just the law is clear on that issue. So that's why I led with that here, because I did not want the government to receive this case and say, oh no, he's aged out. He's 18 now. He's not a UAC anymore. Because there was a settlement agreement that made clear that that UAC determination lasts with the kid even after they turn 18. And now it's actually a federal policy that implements that settlement. So anyway, I led with the procedural issue. And there's going to be a lot of instances where you do something like that, just depending on the case. And this is where, unfortunately, because the law is just so complicated, you kind of have to rely on someone who has experience to be able to identify those issues